Hello, my name is Sharon Levine, and I'm a bankruptcy attorney with the law firm of Lowenstein Sandler. I've been involved with the TWU in the American Airlines bankruptcy case. I've been involved in virtually every major airline bankruptcy case since TWA, and I've worked closely with Tom Roth of the Labor Bureau, your economic expert here, in many of those cases. We understand that there's a lot of information out there, and unfortunately some of it may be misinformation. We are in a bankruptcy process. American Airlines is a debtor. The purpose of a bankruptcy case is to allow the debtor, here American Airlines, to reorganize, including cutting its costs. We're not before a labor court. The 1113 process provides certain limited protections for labor. The company does not need a consensual agreement in order to come out of bankruptcy. In fact, that's exactly the point of Bankruptcy Code Section 1113. The debtor, here American Airlines, can go into bankruptcy court, ask the court to impose relief under Bankruptcy Code Section 1113, and emerge from bankruptcy with its workforce exposed. It's important to note that while the tentative agreements for M&R and stores are difficult, like the 5 last best offers already approved by the 5 other groups, they do contain provisions for equity, profit sharing, and claims subject to bankruptcy court approval, which is something that the debtors, American, would not be obligated to provide without a consensual agreement. As you may know, the Me Too agreements already provided for better treatment for the other 5 TWU groups than existed for those groups at the time that they voted to accept the company's last best offer. And now the 2 agreements that are out for vote have better provisions than the last best offer and have an opportunity to have those agreements also reopened prior to the end of the contract term. American Airlines did file for bankruptcy with more than $4 billion in the bank. Unfortunately, the fact that there's $4 billion in the bank is not sufficient to cause the judge not to impose relief under Bankruptcy Code Section 1113. The debtor continually makes the point that it needs substantially more cash and substantially lower costs in order to competitively compete with the other airlines. The judge will look at the 9 elements that courts generally look at in deciding whether or not to impose relief under Bankruptcy Code Section 1113C. Whether the debtor made a specific proposal to the union, whether the debtor provided the union with relevant information to evaluate the proposal, whether the debtor met with the union to negotiate the proposal, whether the debtor negotiated with the union in good faith, whether the proposal was based on complete and reliable information, whether the proposal is necessary to permit a reorganization, whether the union refused to accept the proposal without good cause, whether the proposal treats all parties fairly and equitably, and whether balancing of the equities clearly favors rejection of the agreement. Whether or not the proposal treats the parties fairly and equitably already resulted in a better and increased offer to the M&R and stores groups from that which was presented originally under 1113. The TWU put on an excellent trial case in connection with the 1113 application. Your TWU expert witnesses were very persuasive. Your TWU fact witnesses were very articulate, very well prepared, and did a very good job explaining to the judge our position, emphasizing that the debtor's 1113 proposal dramatically underestimated the alleged savings from outsourcing and did not properly reflect the fact that we believe that we are being paid below market under their proposal. Bottom line, we are in bankruptcy court. We're not in a labor court. We're in a court that is designed to help the debtor reorganize by cutting its cost and restructuring its business operations. It would be a very difficult ask for us to go into this bankruptcy court and ask the judge not to give American Airlines labor concessions. The bankruptcy court specifically requested that those unions with tentative agreements advise it of the outcome of those votes by August 8, 2012. The reason for this is the bankruptcy court intends to issue its decision with regard to imposing 1113 relief on August 15. If anything changes with this schedule, we'll let you know. Please remember that a vote on this tentative agreement is not the same as the simple vote on whether it's an acceptable or an unacceptable contract. You've been involved in negotiations for at least 4 years. The process will likely take several years longer, but if the court imposes 1113 relief, then you continue those negotiations from a lesser position and without the benefit of a Me Too or a reopener.